Starting on page 83, in another 2011 incident, 9 officers responded to a call for service regarding a man, Christopher, standing in the street with no clothing on. In this case, there is no documented attempt to have a specially trained officer at the scene. When the officers encountered Christopher, they reported that he was speaking religious verses and arguing with himself. They believed he had a mental illness and decided to transport him to a hospital to be evaluated. There is no indication in the reports that the officers sought to have Christopher go with them voluntarily, and instead they sought to place him in handcuffs even though he was not under arrest. In order to handcuff him, one officer held his left arm, a second officer held his right arm, and a third officer attempted to apply the handcuffs. Christopher reportedly became aggressive and violent, attempting to grab and bite officers. The officers and Christopher fell onto the ground. From the officers' reports, it appears that 6 additional officers were on the scene and available to assist in bringing Christopher under control, but there is no indication that they attempted any control techniques on Christopher. There is also no indication that de-escalation techniques or other reasonable modifications were used, such as attempts to verbally calm Christopher down, create distance, or slow down the incident. Instead, the transport van driver exited his van and promptly drive-stunned Christopher. Using a taser in drive-stun mode is to be avoided unless it is necessary to create a safe distance between the officer and subject. BPD had no policy or training, so limiting the use of drive-stun even against individuals with mental health illness or in crisis at this time. Thus, the van driver continued to drive-stun Christopher, an individual in crisis, a few more times in his chest and back area until Christopher became compliant. As a result of the encounter, Christopher and 2 officers received minor injuries, and Christopher was transported to the emergency room for treatment. Before the officers' attempts to handcuff him, he had not committed any violent crime and presented no immediate physical danger to the officers or the public at large. Christopher was never arrested or charged with a crime. In 2016, BPD issued new guidance limiting officers' use of tasers, a positive step forward. Additional work remains, however, to ensure that officers abide by the new guidance. In many instances involving individuals in crisis, the use of force was precipitated by officers' perceived need to bring the individual into immediate custody at all costs, including handcuffing them and placing them into a police vehicle for transport in order to provide necessary mental health treatment. During this detention process, a number of uses of unreasonable force against individuals with mental illness and crisis have occurred when they had committed no crime at all. Instead, BPD's interaction with the individuals was precipitated by calls for help from a loved one, friend, or concerned citizen. That a person has committed no crime weighs heavily against the finding that the use of force by law enforcement was reasonable. Bailey v. Kennedy, 2003, stated that finding that blows and kicks against a man resisting arrest for an unwarranted emergency medical evaluation were unreasonable. In many instances, however, officers have failed to distinguish between people in crisis who are being escorted to the hospital for treatment and people who have committed crimes and are being placed under arrest. From our review of BPD's force reports, it appears that officers make little, if any, effort to de-escalate or engage peaceably with the person in crisis, resorting to the use of force as a first option in order to transport the individual for treatment. If they do not submit to handcuffing or respond immediately to officers' commands, they are often subjected to uses of force in order to physically restrain them rather than neutralize a threat. The only difference is that the final destination will be an emergency room rather than jail. In one such incident in 2010, several officers responded to a call from the father of a man, James, in mental health crisis. The father informed the officers that James was a subject of an emergency petition, had a history of mental illness and hospitalization, and was unarmed. The petition itself indicated that James was not taking his medication, wearing a winter coat in hot weather, and yelling at people on the street and his father. When they could not convince James to open the door, officers attempted to pry the door open with a crowbar, then sprayed 2 bursts of mace in an attempt to force him out of the apartment. Once inside, a lieutenant deployed its taser in probe mode, striking James. When he resisted being handcuffed, Despite the fact that James had committed no crime and there was no indication in the force report that he was a threat to himself or the officers other than resisting handcuffing, the officers resorted to a high level of force to detain the man. The problems posed by, and thus the tactics to be employed against an unarmed, emotionally distraught individual who is creating a disturbance or resisting arrest are ordinarily different from those involved in law enforcement efforts to subdue an armed and dangerous criminal who has recently committed a serious offense. That was a finding by the court. Using effective de-escalation techniques and calling for assistance from a certified health provider or crisis intervention trained officer would have likely prevented the use of force against James. In another incident, two officers encountered a possible mental patient inside a vacant dwelling. The man David was yelling incoherently and would not come out of the building when ordered. The officers entered, and when David became louder and placed his hands in his pockets, one of the officers pointed a taser at him as a threat, purportedly to protect himself and to persuade David to comply with the order to exit the building. David told the police officers that tasers did not work on him. In response, the officer deployed one cycle of his taser in probe mode, striking the man to eliminate the need for a fight. Without waiting to assess whether additional force was necessary, the officer used a second cycle. David was handcuffed and transported to the hospital. The only justification offered by the officer for the second taser cycle was that it was necessary to gain his full compliance. For many people with mental health disabilities or in crisis, the appearance of officers pointing weapons may convey the impression that they are being threatened or arrested rather than provided treatment that is intended to help them. The use of a taser against David in this context was unnecessary and unreasonable, where it had the sole purpose of bringing him into the physical custody of the officers for treatment, and David presented no immediate threat to himself or others. Using effective de-escalation techniques and calling for assistance from a mental health provider or officer trained in crisis intervention techniques would have likely prevented the use of force against all of these individuals. Tragically, some encounters with police with mental health disabilities or in crisis have resulted in uses of deadly force that may have been avoided had officers used tactics to account for the mental state of the individuals involved. For example, in a 2012 incident, a single officer was the first to arrive on the scene in response to a call by a man, Zachary, who informed the dispatcher that he had a weapon and was about to do something crazy. After the officer was dispatched, another officer and sergeant stated over the air that they would respond as backup. The officer did not wait for backup to arrive, however, and request the presence of a specially trained crisis intervention officer, despite the fact that he had prior information that Zachary had a weapon and was in crisis. The officer also made no attempt to contact Zachary inside the house before approaching the door or consider less lethal options for intervention. Instead, the officer went up to the door alone and with his gun already drawn. When Zachary opened the door with a lit cigarette in one hand and a knife in the other, the officer reportedly ordered the man 3 times to drop the knife, and when he did not comply, the officer fired, killing him. After radioing dispatch to inform that he had arrived on the scene, less than 2 minutes passed before he announced that Zachary had been shot 2 to 3 times. Although there is insufficient information to make a determination about the shooting itself, this incident shows how different tactics could have changed the outcome. Officers' use of arrest techniques, including forced handcuffing and prisoner transport vans to detain people with mental health disabilities or in crisis for emergency petitions when they present no immediate threat to officers or the public, may cause people to perceive that they are being attacked or arrested rather than transported for treatment. This perception may escalate the encounter, resulting in additional force. In some cases, officers resort to arresting individuals with mental health disabilities or in crisis in situations where treatment instead of jail would more effectively serve the goals of public safety and welfare and could prevent the need for unnecessary force. For example, in one case, officers responded to a mental case and found a man, Robert, speaking to his mother, who explained that her son had a mental illness and that she was afraid of him. The officers told Robert to leave and put a shirt on, which he did, and then returned. Officers then told Robert he had to leave or would be arrested. When he refused, officers handcuffed him and sat him in a chair while waiting for a transport van to arrive. This decision to arrest and handcuff Robert, a person in crisis, led to unreasonable force. While waiting, Robert repeatedly stood up in what officers believed was an attempt to flee and was kicking his legs to create space around himself. After being told several times to stop standing and stop kicking and that he would be struck in the leg with a baton if he did not comply, Robert refused to comply. He attempted to stand again in what officers reportedly believed was another attempt to flee. One officer struck him in the right shin with his baton. This force used against Robert while he was handcuffed was unreasonable because he had not acted violently, did not present any evident threat to the officers or his mother, and the officers had been informed that he had a mental illness. This force could have been avoided by using de-escalation techniques before handcuffing Robert or by calling a mobile crisis team for assistance. In this incident, as with all of the above incidents involving individuals with mental health disabilities or in crisis, officers did not seem to understand that individuals' mental illness or intoxication might diminish their ability to comply with orders. Moreover, the officers in this incident believed, contrary to the department's policy, that they could not emergency petition Robert because he had not displayed any signs of mental illness in their presence, despite his mother's call for assistance based on that mental condition and her explanation of his history of hospitalization. Instead, the officers arrested him and charged him with disorderly conduct, trespassing, resisting arrest, and failure to obey. All charges against him were subsequently dismissed. BPD routinely uses unreasonable force against people with mental illness or in crisis, even when they have not committed any crimes and when the officers know or should know that the individual has a mental health disability. As a result, individuals are exposed to serious harm that exacerbates their disability and the crisis that precipitated the request for a BPD assistance. This unreasonable use of force against individuals in crisis violates the Fourth Amendment, and BPD further violates Title II of the Americans with Disabilities Act by failing to make reasonable modifications to its policies, practices, and procedures, such as training and de-escalation, effectively using specialized crisis intervention trained officers, and involving mental health professionals as necessary to avoid discrimination against individuals with disabilities. BPD uses unreasonable force against juveniles and ignores widely accepted strategies for police interaction with youth. BPD officers frequently use unreasonable force against individuals without implementing widely accepted techniques and tactics for engaging with youth. Courts have recognized that an individual's age can be a factor in whether the force used against them was reasonable. See Graham 490 U.S. at 396. The test of reasonableness requires careful attention to the facts and circumstances of each particular case. Let's see, Doe X-Rail Doe v. Hawaii Department of Education noted plaintiff was 8 years old, and in an analysis under Graham of whether force was reasonable, finding a reasonable jury concluded that a deputy used excessive force where the appellants produced evidence that Deputy Bernardo, a 300-pound man, violently jerked Laura, a 10-year-old child, out of her living room chair and dragged her into another room. We found that BPD officers engaged in unnecessary and excessive force with youth and failed to adjust their tactics to account for the age and developmental status of the youth they encounter. How the hell does a 300-pound man drag a 10-year-old out of a chair and into another room? That's just, a asshole cop that knows that he can get away with bullshit, and he just wants to screw with a little kid. That's bullshit. Okay, I continue. For example, in a 2011 incident, an officer noted a 5'2", 85-pound female youth standing with a male in a known area for high drug trafficking. The officer in charge who investigated the force reported that the involved officer was familiar with the female juvenile and her past history for selling CDs. Not drugs, CDs. The involved officer's incident report does not mention any history of selling drugs, but states that she suspected, oh man, this is a woman. She suspected the female was a missing juvenile. Regardless of the basis for stopping the youth, the officer got out of her patrol vehicle to identify the female. When she did so, the youth and the male began to walk away very quickly. The officer commanded the individuals to stop, but they did not comply. The officer again commanded the two to stop. When they continued to not comply with her command, the officer discharged her taser in probe mode at the young 85-pound female, which gave an electric shock. The youth stopped and supported herself on a fence, and the officer discontinued the electric discharge. When the officer discharged her taser, she did not have probable cause for an arrest. There is also no indication in BPD's own reports that the youth was threatening the officer or others. Rather, she was simply walking away. Even assuming that there is reasonable suspicion for a stop, refusing to obey an officer's command to stop when the officer has no probable cause to arrest and there is no threat to the public or officer does not justify the use of a taser. The officer's use of a taser was unnecessary and excessive. The chain of command failed to identify any issues with the officer's use of force. In another incident, in 2010, two officers approached a group of individuals who were standing on a sidewalk in a residential neighborhood and verbally warned the small crowd to disperse. A juvenile, Brian, and his sister walked onto the steps of their home, remaining outside. When one of the officers approached Brian's sister to warn her about loitering, she informed the officers, yelling and cursing, that she lived in the house. The officers did not appear to dispute her claim that she lived in the house. Their reports do not show that any effort was made to confirm whether it was her home. Nevertheless, the officers continued to warn her to leave and cease causing a disturbance. They eventually attempted to arrest her for non-compliance. One of the officers walked up the steps of the sibling stoop to attempt to make the arrest. Brian attempted to block the officer, and the officer began to struggle with the juvenile. According to civilian witnesses' statements that are summarized in the department's reports, the officer punched Brian in the face. The officer also used oleoresin capsicum or OC spray against both siblings and arrested them for loitering, resisting arrest, and assault on a police officer. All of the officers' uses of force against the siblings who were standing on or in front of their own property were unreasonable. These individuals were placed into the criminal justice system for standing on their own steps. And that's what I have consistently said. A lot of the times these cops come up with a bunch of bullshit just to get people into the system. That is their sole goal in life, to create criminal records. And even if charges are dismissed, once you're in the system and you're applying for a job, you have to, in most cases, disclose that if you're applying for a really sensitive job. And then a huge investigation starts and you may be able to obtain the job, but you're hassled over bullshit that shouldn't even be on your record. And when you go to court, if you're found not guilty, even if your record is sealed, let me tell you, your records are never truly sealed. The FBI can look into your records, and any police department that you are stopped by, on the computers in their police cars, if they have computers in their cars, they can see every single thing that brought you into contact with law enforcement. As an example, when I was a minor, I was arrested along with a bunch of other people for a minor crime, okay? But I did have to get a lawyer. Fortunately, my dad knew people, and I was able to get an excellent lawyer. By the time he got done, all the charges were dismissed, and my lawyer was thinking. He requested that my record be sealed, which the judge agreed to. 40 years later, I'm stopped by a Texas police officer